Hi, everybody. How's it going? We're going to get started in just a little bit. Please feel free if you'd like to put anything in the chat. We're going to be using chat or Q&A for questions. That way, wherever it feels most comfortable for you. You can just test things out if you like. I'm going to give maybe one more minute for folks to join us, and then we'll kick it off. Okay, 7:02. I think that's a good time to get started here. This is being recorded, and you'll receive a recording in an email tomorrow. But first of all, we're just so glad you joined us here today. I have the pleasure of being with my teammate, Rhiannon Johnson, and with our presenter tonight, Donna Watson. She is the Assistant Vice President for Country Club Trust Company, but also an estate planning attorney right here in Kansas City, Missouri, and CEO of My Legacy Experience, LLC, and the author of a book you can find on Amazon and also at the Kansas City Public Library called My Legacy Experience. I'd like to make sure everybody understands that this information is being provided to you. It is not legal advice. And if you have any specific questions about your very own particular situation, please seek legal assistance from an attorney. With that being said, if you have any questions, like I said, please go ahead and feel free to put that in the Q&A or in the chat. We'll be monitoring that, Rhiannon and I will, and we'll take breaks during the presentation. Before we proceed to the presentation from Donna, I want to make sure you know that this is part of a series, the second in a part of a series. And we have next Monday, we have Navigating the Trajectory of a Life-Altering Illness, and November 30th, Avoiding Funeral Bankruptcy. So without further ado, Donna, please take it away.
Thank you so much. And I'm so excited to be here to participate in this conversation about estate planning. And it is a conversation about estate planning. It's not a lecture. It will be informative, but I want you to feel like you have the opportunity to engage in dialogue with us about these components, because it's such a timely topic given the climate of the world, given the fact that we're in a pandemic. People are becoming more aware and motivated to participate in estate planning. So let's begin our conversation. Are you ready? Okay, so when we think about estate planning, one of the things that we really want to do is make sure that we are mitigating risk. And there are risks associated with estate planning. There are risks that are associated with estate planning dealing with you individually and with your property. And right now I want to talk about the risks associated with you personally. So there are documents that are in place to assist you with protecting you individually. When we talk about the durable power of attorney, we're talking about a document that gives someone the authority to handle your financial affairs. And so when we talk about the authority, that gives them the ability to, and sometimes buy or sell real estate, to enter into contracts on your behalf. They have access to your banking relationship, and you give this power to someone so they can serve as your agent, like your attorney in fact. And that's important because should you become incapacitated or you are unable to take care of your financial affairs, this durable power of attorney comes into place and it allows a person to act on your behalf. Now, this durable power of attorney can be provided in two ways, or there's two categories, I would say, of the durable power of attorney. You have the shifting or the springing durable power of attorney. And when we say shifting, it just allows someone at any point to just kind of shift into that role, and they can act on your behalf, as opposed to a springing power of attorney, which arises under some particular circumstance. So usually incapacity will be that springing event that will give power to that authority. And so when we talk about that springing durable power of attorney, sometimes that can be problematic, because there may be a situation where you would have to be adjudicated or found legally incapacitated or incompetent. And so there may be a delay in that person being able to serve on your behalf. So you really want to consult with an attorney whether you want this durable power of attorney to be shifting or springing. And in addition to that, you really want to think about who you want to represent you. So I know in a lot of situations, people think the next of kin, and that's usually how they decide who they'll appoint as their durable power of attorney. But that's not always the best solution. But think about situations where your next of kin may live in a different state than you, or they may be just financially irresponsible. So maybe that's not the best choice. So whenever you do decide to select a durable power of attorney, someone who's going to act on your behalf, you want to consider their competency level, their geographic location, and you want someone that you know would advocate for you and look out for your best interest. And that sometimes isn't your next of kin. So just be very mindful and thoughtful when you're appointing that durable power of attorney.
Hey, Donna.
Yes.
This would be a great time just to share with everybody that in the chat that was sent to everybody, you've already shared a PDF from the Missouri Bar Association. I want to let you know too, I have hard copies of this. This is the durable power of attorney for healthcare and health care decisions. And you'll have an opportunity, if you would like the PDF, that's in the chat. But also, if you'd like this mailed to you, you'll have a chance for that also. Thank you.
Thank you. And I think it's a document that's become increasingly important during this time of pandemic, because people have become ill and then become incapacitated. And so you really want to have that protection. I have a durable power of attorney that I executed for someone that I trust. There really isn't anything wrong with me that I know of, knock on wood. But I think it's a good protection measure. And so it's something I really would like you to think about and put in place. The document that we're sharing is, as she said, given by the Missouri Bar Association. And so it's a credible source. It's a document that you can use and just have in your arsenal to help protect you as a person. So now let's talk about that living will healthcare directive. So we talk about having someone that's going to act on your behalf for your financial matters, but there's also someone that will act on your behalf for your healthcare matters. But even aside from that, there are things that you can do to help make that role for someone easier. So when I think about that living will, I think about the document that outlines what medical treatment I want and what medical treatment I don't want. So there are things like, do I want resuscitation to occur? What medical treatment do I want? Maybe I am someone that's vehemently opposed to surgery. Maybe I don't want certain medications, or I don't want want to be on a ventilator to prolong my life. You can outline those decisions and those choices in that document. And I'm going to tell you what's so great about doing that. So anyone that steps into the role of being your healthcare power of attorney, and we'll talk about that one next, but anyone that steps into that role, they're just actually fulfilling your wishes. And I can tell you, as being someone who has served as a caretaker for a family, and understanding what preferences someone has is a blessing, because you don't want to put someone in a position where they're making decisions. They feel guilty. They don't know what they should do, what they shouldn't do. So just relieve them of that kind of guilt. Outline those preferences in this document. And it's so helpful because honestly, in a time of grief or in a time of stress and strain, you don't want to, that shouldn't be the first time you've had a conversation about whether did mother want to be on the ventilator? Should we give her this medication? You don't want to make those decisions under that stress. And so I think these are the things that we need to start talking about as families, as citizens, as friends. It's not a popular conversation, but it's a necessary conversation. And especially now in the pandemic, it's really important that people know what your preferences are. So in addition to this living will, I was alluding to the fact that there's another document, the healthcare power of attorney. So that gives someone agency over your healthcare matters. And so it allows a doctor or a healthcare facility to speak with you on behalf of someone's health issues. And you know, with HIPAA and privacy laws, you really can't have free-flowing conversations about people's health and welfare. So this document allows you to speak to a doctor or healthcare practitioner on someone's behalf. And it's so important. So I have one that's filed with my primary care physician, my gynecologist, all of my dentists. I have them with all of my physicians. And I think it's just a good best practice. As I said, I don't think anything is wrong with me. But if something should happen to me, there's someone that can immediately step in and begin the conversation to act on my behalf. So I think when we're talking about estate planning, it's great that we want to build financial estates. That's very important. But we also want to make sure that we're protecting ourselves individually. And that's the first R in ready. We're going to manage that risk. Are there any questions about those three documents? Okay, so we'll go to the E, which is the estate. And when we're talking about estate planning, I think people get kind of intimidated by the language. Estate planning. Who has an estate? Oh, those are people that were on shows, and I'm showing my age, like Dynasty. Oh, they had an estate. What was that? South Fork. Okay, I don't have an estate. I just live in a home. But really, an estate is anything that you own at your death. And we all have an estate. Now, some may be valued differently than others, but we all have an estate. So whether that's your savings account, certificates of deposit, cash, IRAs, vehicles, personal property, that's your estate. And guess what? You've worked hard for that. So you want to make sure that that disposition at your death is occurring in the way that you contemplated. What you don't want to happen is the IRS or the state of Missouri Department of Revenue or the Missouri.gov get access to your financial holdings, and they are diminished through tax or levies, or they a sheet to the state. What you want to do is make sure that you have created a plan for each and everything that you own. And one of the things that we now own that I think people take for granted, and it's getting a lot more attention, are digital assets. So we have Facebook pages, and okay, now I'm showing my age again. We have Twitter accounts, or we have Instagram accounts. And so who's going to access those platforms at my death? Who has access to that? How will they get access to that? And so I think it's important that we make a plan for each and everything that we own, because that is not only the responsible thing to do. I'm kind of a control freak. I want to make sure things happen the way that I wanted them to happen. I worked hard, and I want to make sure that it is distributed in the way that I think is most advantageous. And so I want to say, yeah, I don't want the state to determine what happens to my property. And so just understanding that this is something that applies to everyone. If you see something on that screen, if you have stocks, if you have cash, if you have vehicles, you have an estate. And so this applies to you. Any questions? Okay, so the next term I want to talk about are assets. And I think when people think of assets, they think about anything that they own, what has value, and that is the traditional definition of an asset. But in the context of estate planning, I want to look at assets as two categories: probate assets and non-probate assets. And the reason why I use this terminology and this classification is it really guides you and dictates how property is distributed at death. If you have a probate asset, then that asset is under is subject to the authority of the probate division of your state of Missouri. You have to comply with the legal process of the probate court. And that distribution is going to occur in accordance to your will, or if you die without a will, it'll be distributed in accordance to intestate distribution, which is dying without a will, which is in essence heirs sharing equally. Okay, so those probate assets are the assets that people talk about when they say I have to go to probate. I'm going to probate to get access to a house, get access to a car. Those are the assets that they're talking about. Not all of your assets are going to be probate assets. Some of your assets will be transferred, legally transferred at your death by operation of law or by provisions that are outlined in a trust, should you have a trust. And that's important to note because not everything you transfer needs the legal formalities that occur in the probate division. And I say that because sometimes we may own property jointly. And so if one person dies, that property transfers to that person automatically. It's just like automatic. And so there's no need to go to court in order to get title or custody of that asset. Additionally, there are opportunities for you to designate beneficiaries on certain assets. And so then the designation allows that transfer, that ease and transfer at death. And that's really convenient. I think about, I own a home and I have a deed, a beneficiary deed that I filed with the county. And so upon my death, it transfers automatically to the person that I designated. And so they don't have to go to court to get authority over my home. That made sense for me because I don't have children that would be vying over the house. My house is my biggest asset, and the person that I designated, I know will either sell it or may rent it out, but I know that they would take good care of that asset. So there was no reason for me to make it a probate asset. So I think it's very important to understand what type of asset you have, and we'll learn how to recognize our assets for later on in this conversation. But really being able to be clear about whether you have probate assets or non-probate assets is going to be huge. Any questions?
Donna, I would just jump in. I put the PDF in our chat, in our shared chat, but I also have a hard copy of this. This is the Missouri Bar Association Probate Law Resource Guide, and it just gives you some more information in addition to what Donna shared already.
Thanks so much.
And Donna, can I just ask you a quick question? When you were talking about beneficiary deeds, it makes me think of life insurance, like when we're filling out, our open enrollment things and stuff.
That's right.
That's an example. I've
That's
already decided, right?
that's a perfect example. So you have a life insurance policy, and at your death, there's value there, but that value is automatically transferred to whoever you designate. I also think about if you have retirement accounts. Usually, those retirement accounts you can designate beneficiaries. Again, just a easy transfer at death. You don't have to go to the probate division in your state to get authority over those assets. That was a great example.
And we have a question too. Is there anything that must be probate? Or can everything be non-probate?
Okay, so there is this tendency to believe that probate is bad. I mean, like, oh, it's bad. It's not always bad. Sometimes there are compelling reasons to go through probate. I think about like young parents who may die. They have a will. They want that will to be admitted into the probate court. They want that will admitted because they may have designated who would be a guardian for those children. And so that can only be, that authority can only be given in the probate court. Then you may have minor children who may not they're not of age to have authority over assets. They're not the age of majority. So it would be appropriate to go to probate to address that situation. So no, I don't think probate in itself is bad. There are just certain things that I think people tend to handle differently than through the will. And it's just easier and quicker and cleaner when you think about if there are items that you own that you already know who you want to own them after your death. If you have a small, and I say small, if you have an estate that's under a certain amount of dollars, it may not make sense that you're creating a probate estate to pay legal fees and court fees when you have a bank account and a life insurance policy. It may make sense to just go ahead and put someone on that account, designate that beneficiary, and keep moving. So, and I think if you have questions about that, that's the perfect time to speak with someone about it. Okay, so I was talking about these two classifications of assets. So let's talk about what these two classifications of assets, how that plays out in terms of the distribution process. So distributions at death. So I was talking about some distributions occur at death out of operation of law. There are no legal formalities. They're just automatic transfers at death. So we talked about the joint title. You know, a husband and wife, the wife dies, the husband automatically gets the bank account because they owned it jointly. And so what that means is, what the law says is they owned it joint and severally. And so once the spouse has died, that spouse's portion, if you will, is all owned by that remaining spouse, that surviving spouse. So you have one person that's able to take title to the entire asset, okay? Beneficiary deeds, I talked about that earlier. Beneficiary designations. Sometimes on your accounts, you can have transfer on death notations. So I may have a bank account, and so on my bank account, I have another person's name. I can own it jointly with someone, or I could have a transfer on death notation. So that means that during my lifetime, that person doesn't have access to that account. But when I die, it'll just transfer to them. And that's a good option if you're concerned about owning property or having it titled in 2 or 3 names, because sometimes we know how we are and we can manage ourselves, but sometimes people have different philosophies. So I think about parents, when they're parents and kids, young kids, and they're starting out, and so the parents are on the bank account with the kids, but it's to give them guidance. But then they know, like, sometimes there are some kids that, oh, I'm on my parents' bank account and I'm just going to go ahead and write some checks. And so that doesn't often happen, but I'm just saying there are times where you may not want to hold title to an asset together. And so it may make sense to have a transfer on death notation or payable on death notation. It's just this will be paid to this person at death. And so these things happen at an operation of law. There's no need to file anything with the court. It just happens at an operation of law. It's quick, it's easy. And I say quick and easy, relatively, everything's relatively quick and easy. Everything's relative, but I think it's important to note that these don't have the same legal formalities as distributions that occur under a will or a trust. Okay. Any questions on those operation of law? And I'm using this terminology to try to break it down. So I think one of the things about estate planning, there are so many terms, and Jenny's going to give you a glossary, but I think the language can be intimidating. And so if you just kind of look at it as this is something that happens and I'm not going to have to go to court to make it happen. Think of it that way. Okay. All right. So now let's talk about distributions that occur at death under a will. So someone can say, well, I have a will, so that's going to let me know what to do, and I'm just going to distribute this property under the will. You still have to, you're going to probate court. In fact, the will is just a one-way ticket to probate court. And I think sometimes people don't recognize that, oh, that still means I'm going to court. Yes, it does. And you should name a personal representative in that will, someone who is going to have authority and help kind of manage this whole probate claim. They'll handle the petition, they'll work with the attorney, they'll complete the inventory, they will actually execute everything that you want done outlined in that will. And that personal representative, very much like that durable power of attorney, needs to be someone not only you trust, someone that has the capability and a skill set to do that. Because what you don't want is someone who's going to be overwhelmed by this role. You don't want to put someone in a position where they can make a misstep. They may miss a deadline or just be overwhelmed. You really want to find and identify someone that you know could handle this. And whatever attorney that they're using will help walk them through that process. But I think it's still important to be wise in terms of who you select. And this will requires filing an original valid will within the statutory period, which is 1 year in Missouri. And so we have to know where those wills are, and we have to know which will is valid. So I think over our lifetime, we can write a will and we can change that will. And we can change it 2, 3, 4, 5, 10 times, okay? But what you want to do is make sure that the one that is the most recent and the one that you want to be binding is somewhere where people can find it. Sometimes people leave the will with their attorney, and the attorney will file it with the court. Or sometimes they're on deposit, and I say deposit, it's kind of like a little holding through the probate court. Or sometimes they're in a safe deposit box, and I think that can be great if someone has a key to that safe deposit box, or they know that it's in the safe deposit box, safety deposit box. So just make sure that that original valid will is accessible. And so then we talked about presenting the will, filing the will with the court. And during that process of probate, you're going to have to give an accounting and inventory. And you give an inventory of all the assets that are subject to the probate court. So that's what we were talking about earlier. So you'll give an accounting and you'll give a list, an inventory of all of those assets. And that will is going to really direct how these assets are going to be distributed. In your will, you may have 3 kids and you'll say 1 kid gets this, 1 kid gets that, 3rd kid gets this. Okay. If you have children and you decide not to leave them anything, you would want to put a provision in specifically disinheriting those heirs. And so when we talk about this will, I have strong opinions about wills being drafted by people that have familiarity with this process. Because I think what has happened, there's YouTube Law University. And so in YouTube Law University, everyone can get a document, they can create their own legal documents, and they think that they're binding, but they may be at risk of being challenged or being found invalid if they don't specifically disinherit, or they aren't executed with the formalities that are required in your state. And so it's very important that you speak to someone about that will, because what you're doing is you're directing distribution at death, and you want to make sure you get that right. So I think it's just very important that that will be drafted or at least reviewed by an attorney who is competent and practices in estate planning. And I think that's one of the other issues that I see, especially with people who may be sole practitioners. Oh, I do criminal law, I do estate planning, I do patent law, and you can't do all things well, right? So you want to talk to someone who has the expertise to know what this will should look like, what a valid will is in the jurisdiction that you live in, and can give you good advice in terms of provisions that you want to draft or create. So that's my thoughts on the will. Any questions?
Donna, yes, we have a question about how often people should review their beneficiaries. I'm trying to be careful that we're not giving legal advice, but I figure a general idea of how often people should review.
So we'll talk about that. That's one of the letters in my Be Ready acronym. So, but to give you a quick preview, I think that these are things that you should review annually. And I'll give my reasons why a little bit later in the presentation. But so much can change, and so it's important to look at this on an ongoing basis. Any other questions? Okay, so then there are distributions at death that occur through an irrevocable trust. And I think a lot of people have heard the term trust. Oh, I have a trust. What does that really mean? And trust is just a fiduciary responsibility. So I serve as a trustee to a beneficiary. And the beneficiary is someone that the grantor, maker, settler, use all those terms interchangeably, has created provisions for. So this trust document outlines how property will be managed, sometimes during the lifetime or sometimes during lifetime and through death. So the trust document has what's called dispositive provisions, and those provisions say how things will be distributed. Some of the common dispositive provisions I see are income for life for the maker, the person that created the trust, and then at death, outright to 3 beneficiaries, let's say. Or I see income for life, discretionary discretionary provision that says principal for health, education, maintenance, support. So that means whatever this trust asset is, whatever it's earning during the year, that's what's supposed to be distributed during lifetime. That's the earnings or the income. And we see that when people have investment accounts, and those investment accounts are held in trust. So that means the title of that asset is Donna Watson Revocable Trust. It becomes irrevocable when I die. So when I think about the trust document, that trust document really outlines how things will be distributed. The trust document also says what powers that trustee has. That trustee has the power to invade principal for health, education, maintenance, support. That trustee has the power to sell assets to give discretionary distributions. And the discretionary distributions can be based on a variety of things. It doesn't always have to be health, education, maintenance, or support. So those trustee powers are outlined in that trust document. But more importantly, I think one of the things that I see is that people may go through the effort of creating a trust, getting a trust drafted, and then never funding that trust during their lifetime or at death. And so when I say funding the trust, what I really mean is, I mentioned earlier, I have a home. And if you look up my name, you'll see I have a home. I could also own, my trust could own my home. So if I've created a trust, I would name, the owner of this home would be the Donna Watson Revocable Trust, dated May 5th, 2017. Okay, so that would be the date that I created the trust, and that would be the owner of the trust. So I, as an individual, no longer own my home. The trust owns the home. And people put their assets in trust for a variety of reasons. There's some protection against creditors. There's maybe an incentive to continue to collect and compile your assets so that they can continue to grow over time. And you know that you don't want an outright distribution at death. That's what we were talking about with the will. This allows assets to continue to be invested over a period of time, even after your death. And you can continue to allow those assets to grow, and you can take care of whoever you might have designated as a outright owner of property under the will. So that irrevocable trust gives a lot of flexibility to the maker. Also, what I want to talk about is when people own property in a trust, it's a private matter when they die. Unlike the will, you can see probate matters. There are people, I know they do this because I had to probate an asset, or I had to file a petition for someone, and you could just see everything that was going on. Oh, there's a house. Oh, there's an account. And let me tell you, there are opportunistic people who peruse probate filings, and they know that you're selling real estate, and they will stalk you, and they will they'll be very aggressive because it's a public proceeding. And if you're looking for some anonymity and some privacy, the trust may be an option. You don't want everyone to know what you have and the value. And so I think when we're talking about distributions at death, the irrevocable trust is, or revocable trust during your life, irrevocable at death is an option. And I think what's also important is, if you are vacillating between whether I should have a will or should I have a trust, I say everyone should have a will, because sometimes there's that one asset that you might forget about. You know, when we were talking about probate assets and non-probate assets, you may have a bunch of non-probate assets, but there's that one account you forgot to put a designation on. You own it just solely in your name only. And so then if it's over a certain amount, gosh, now we have to go to probate. And so you want to go to if you go to probate, you want to go to probate with a will. Now, there are some times where the will is not presented, but that's a strategy that an attorney would have to walk you through, okay? They do that sometimes because if they know that there are heirs, and those heirs would have taken regardless of the will, and if it would have been like the same outcome, then it might have made sense to just walk through the alternative to probate, which would be like a determination of heirship. That's for another conversation. What my point is, there are options. There are options that you can pursue if you don't have a will, but I think it's very important that you have a will.
I do have a question, and it's I actually have two questions. But first of all, just want to make it clear, irrevocable trust means after you pass away, there's no contesting it. Like it's
It,
wrapped up, locked up.
yes, it
But
can't be changed.
during your lifetime, you could change it. Like if some circumstance.
Yes, so I could create an irrevocable trust during my lifetime, but most people don't because they want to be able to change it. And life happens. You know, who I was at 20 is very different from who I am in my the age that I am now.
30s.
In my 30s, yeah, let's go with that. Who I am in my 30s, and so things may change, and so you may have had an idea that you wanted to leave money to your children. But as you've gotten older, your children are grown, they have their own financial resources, then you may decide that you have a charitable intent. And so you want to pursue an amendment or restatement of that trust so that you can make those type of distributions. So I think during the lifetime, generally, it's revocable. You have the ability to make changes. At death, it becomes irrevocable. So you can't change it because you're no longer there.
Okay, thank you. The other question I have is about if you can. I think this is a little bit too specific, actually. But I think it's a little bit too specific. I'll email it to you later. And
Yeah, we could talk offline, definitely. Okay, so those are the three ways we're distributing property at death. So then there's this other distribution method. I didn't have a will, I didn't have a trust, I didn't put anybody's name on anything. You all figure it out. And if you notice, you'll see cash is kind of up in the air. You see cash up in the air because that's what's about to happen. I mean, who knows how we're going to have to proceed because you didn't put a plan in place. So I think about this example. I have an account that had $50,000. I say $50,000 because there's some small estate affidavits of $40,000 that would get you an abbreviated kind of proceeding. But no, my account's $50,000. So then now I'm going to have to get an attorney, and then I may have to pay a bond to whoever's going to serve because I didn't name someone in that will. You name someone as your personal representative. So then that person's going to have to pay a bond, and then I'm going to have to pay legal fees. And you pay legal fees, but you pay legal fees based on the value of the assets that are under the jurisdiction of the probate court. And so all of this is just like complicating the matter, when really on this account, I could have just put a payable on death notation, and that would have been the end of it. So I think what I'm trying to illustrate is this is a default distribution method. Sometimes things happen, but this shouldn't be the way that you conduct estate planning. This default, let the state decide, let the people pick up the pieces and keep it moving. That's not what you want to do. You want to be in a position where you've been thoughtful and methodical about this process. You owe that. I say you owe it. You owe it to your family and your friends, whoever is going to benefit from what you've worked for in your life. And I think it's important to put something in place. So finally, this kind of loops into the question that was asked earlier in the presentation. Why is a year-end review? And why do I say we need to do a year-end review? Donna, I don't want to look at my stuff every year. Well, you should, because guess what? Things change every year. Every year there's a birth, and every year there's a death. And I think about times where there's a surviving spouse, and the surviving spouse got all of the property because they probably held some of this property jointly. Great. So now they have this property that they own individually. So then what's the next step? Have they made some changes so that now someone else can take this property, will take this property at their death? what provisions have they put in place? And I think sometimes that the second step is not considered. We don't think about when we take property, when we get property from someone else, what it's going to look like. How are we going to then transfer it after our death? There's births during the year. So then you have a will that says, I'm going to give to Amy, Bobby, and Charlie. And now there's Donna. Well, Donna wants something too, and you want Donna to have something. So maybe you might need to make some changes in terms of your beneficiaries. Maybe you have a class of beneficiaries, all grandchildren. Okay, so, but review it. Or sometimes this is what's happened. I can remember times where someone has gotten divorced and remarried and they didn't update their original designations. And so now that ex-wife is going to get something. That wasn't what you wanted to do, but you never looked at it again. And I'm going to tell you the days that I think about doing this year in review. There are those cold, snowy days that I can't get out anyway. And it's just one of those days where you're at home and you've watched all the Hallmark movies you can, or whatever is your favorite show. And it could just be a day that you're off from work, and it could be a day that you're just around the house sitting. Use one day a year to really review everything you've purchased during the year. Look and just be clear about title, be clear about beneficiary designations. Look at that will, and think about the circumstances that may have changed. So I'm going to say, look at all of your titles, look at all of your accounts, look at your deeds, look at your beneficiary forms. I have accounts on there twice. Well, I really want you to look at those accounts. And if those circumstances have changed, then it's time for you to make some updates. And I'm going to tell you, it's better to make an update, spend one day making an update than going through 6 months to a year trying to get authority over some assets that you could have cleared up if you had just made a few reviews during your lifetime. Okay, so this has been a conversation, and yes, in some ways it's been a one-sided conversation, but it's been a conversation about estate planning. But I think it's important that we have the takeaway. So you weren't on this call just to hear about estate planning and think, oh, now I'm really knowledgeable. And you just take that information and store it. I want you to do something with that information. So make a commitment to yourself. By December 31st, 2020, I am going to what? We gave you links to a durable power of attorney. Maybe you need to get that put in place. Maybe you need to consult an attorney about a will. Maybe you got divorced and your first wife is on all of your accounts. Maybe you want to update them. I'm not saying you should, but I'm just saying you might want to. So I think it's very important that you decide, pick one thing, because what I do know about estate planning, this can be overwhelming. But if you pick one thing, so today's the 15th of November, so you have 45 days to implement something, you're going to feel accomplished. You will have done something to not only prepare yourself, but your family and your friends for your passing. And you've put something in place to perhaps create some generational wealth, which is always great. And I know that this can be a morbid topic. No one wants to think about their demise. But unfortunately, the reality is we're all going to pass. Now, I'd rather go out with a bang, and I mean a bang, like all my stuff is together, than go out and it's just kind of like, gosh, she made a mess and she left us with a lot of struggles. So just think about that. Oh, here's a poll. What will you do by December 31st, 2020?
This is something I just put together. If there's something else, I'd love to see, you don't, this is anonymous. Nobody sees your answers. This is just to sort of be like, yes, I'm going to do something. Because absolutely we want to, and that consider my representative is what Donna was talking about, like who is going to represent you, who's going to take care of, who's going to represent you in court so that you are protected. So it's just something to think about. There's so many choices that you've seen, but this is just a way to kind of be like, is this what I want to do? Maybe you want to do all four. Maybe there's more. But I thought this would be a great way to get have a little bit more interaction.
So I think it's important that you make this year the best year that you can by putting something in place. Oh, keep doing that. Okay, so that's my presentation. I'm Donna Watson with My Legacy Experience. My website is mylegacyexperience.com. Same email. I'm on Twitter. Some of those things I use more than others, but I am available. And I do have some resources if you need additional information. And it's information. As she said, this is not your specific legal, it's not advice for your specific legal situation. If you do need to speak to an estate planning attorney, we have some people I can refer you to, and I think that it's important that you begin this process because it's important, and you will be glad that you did. I thank you for your time. Are there some questions in the Q&A?
I do have one more question, and maybe this is too specific, but this is what I was going to check in with you about. But on your estate slide, where you had all of the different things like IRAs and certificates of deposits and savings accounts, is the will the place where you would decide who gets what and how it's delivered? Like if you wanted to split it among family members or friends or charities, would you put that in the will? Or
you can put that in the will, and you can use other means to designate the distribution. So like let's use the IRA, for example. The IRA, you can put a beneficiary on an IRA. So I may just say it goes to Donna and Susie. And so then the will wouldn't even come into play because I've already designated who would own that at my desk.
That's really, again, that's kind of like our life insurance things that we're doing where I didn't even know you could do that. That's really
Yeah.
Thank you. And I also put a link to my page on the library's website, and there's information there about the library's policy, which is why this is not specific legal advice. We are not in that business, but we definitely want to put resources and information in your hands. And we're awfully glad that you all joined us. Donna, thank you so much. We sure have enjoyed reading very complimentary things about your presentation and all of the information. I think this is just what we needed, certainly as part of this series. I'm really grateful to you.
Thank you so much for having me. And thank you all for joining in today.
And we'll be following up with an email. You'll get more information, more links, and also a survey. So please, if you'll just take a couple moments and fill out that survey, we'd appreciate it. All right, if there's no more questions, then we'll close it out for tonight. And again, thank you all for your time.